Constitutional Court, where the IEC is seeking clarity on its powers to enforce Section 47 of the Electoral Act. This after the Electoral Court overturned the decision to disqualify MK party leader Jacob Zuma from contesting in the May 29 elections over a contempt of court conviction. Now, joining us now is Michael Atkins. He is he's an independent election analyst. Michael, thank you so much for your time. Welcome to Newsroom Africa.
Hi, good afternoon.
Good afternoon to you, Michael. First and foremost, we know that this is an unprecedented case. Just based on what we've heard today so far, does the IEC have a strong case?
Well, you know, the legal arguments are very interesting. And I would say our legal experts would be better placed to comment on the strength or the merits of the case. Certainly, despite some criticism, I would say that the IEC is correct to be bringing the case, which is a slightly different question, I know, because it's important for voters to have clarity when they go to election day to know whether Mr. Zuma may be a member of parliament or not. You know, this is not just an academic matter. It's not just a point of law for future elections. Voters have the constitutional right to make political choices. And our courts in other cases have held that correct access to information is an important part of making political choices. So again, in order for us to have our free and fair elections, the information about Mr. Zuma's status is important for voters.
And how important is it also in terms of this perhaps being a landmark case with a general understanding of how this law applies even for future elections?
You know, it is when a question is raised, when there's any doubt over something, it's important that there is clarity on it. You know, there may or may not be cases in future. It's unlikely that we're going to have 100 people in the next election who fit the precise conditions. But it is very important that the electoral authority are seen to be acting correctly, that the processes of law are seen to work correctly. So I wouldn't say that this sets a precedent that will affect a lot of people, but it's more that when there is a question, when there is a challenge, we go through the process and that we reach a satisfactory outcome, whatever that outcome is.
Was this appeal application a good move by the IEC? Is this move in the best interest of the country? I mean, from a short-term point of view, from a long-term point of view, with all things considered, especially in light of past potential security threats when it comes to the case around former President Jacob Zuma?
You know, there have been various people who have attempted to cast the decision of the IEC to appeal as a bad move or a risky move or, you know, somehow improper. The first thing is, in law, there is nothing improper with appealing at any point. The actual merits of the appeal will be then seen. You succeed or fail. The second thing is, I do not see how our electoral authorities should be intimidated into not carrying out a lawful action because they are concerned about what might happen on the basis of certain things that certain people have said. We need, you know, this idea of without fear or favor. The electoral authority has to be able to pursue a correct understanding of the law without fear of the consequences, because if they can't, then people can manipulate the process in future by creating this idea of a threat to stability. And as I say, Section 19 of the Constitution, we all have the right to make political choices and then to have free and fair elections. For people to... Sorry, carry on.
No, I was going to say, on that note, is there a realistic possibility that this case could delay the elections?
I think that's extremely unlikely. Given the other matter that has been disposed of this week, in which the question of a delay in the elections was aired and the costs and everything else, the court is very well aware of the matters at hand, and the logistics of preparing for the election are actually not affected by the outcome. So, for example, 4 days before the election, the court could rule. Whichever way they rule, it's not actually going to change the preparations. It won't change the ballot paper. So the answer is actually no. It's helpful for voters to know ahead of the election what the outcome is, but it does not affect the preparations of the IEC at all.
One would have thought that this is something that should remain an electoral court matter. So for the clarity of our viewers at home, why is it being argued in the Constitutional Court?
Well, the Electoral Court obviously heard the appeal against the IEC's decision. And although there is an old provision in the Electoral Act that electoral court decisions may not be appealed, the change to the Constitution about 12 years ago that made the Constitutional Court the final court of appeal for any matter in the country, and not only constitutional matters, in a way overrides that provision. And we have had other matters, even before this year, that have been appealed to the Constitutional Court from, or have been appealed from the Electoral Court. So there's nothing in law that says the Electoral Court is where the buck stops. In ordinary matters, in interpreting ordinary electoral decisions, sure. But this is an interpretation of the Constitution, so it's quite appropriate that the Court hears it.
100%. Advocate Tembeka Ngugaitobi argues that remission is not a reduction of sentence. Explain this in layman's terms, please. What is the difference, and what bearing does this have on the IEC's application?
Well, a sentence is given. Now, that sentence stands. We all understand that if there is a pardon, not only are you released from prison if you are in prison, but your record is removed from the books. So a pardon, the nice term is, expunges your record. It wipes the slate clean. A remission of sentence is a general term, which means people who are currently serving can have that the time of their sentence cut short. It does not change what the original court said or did. So that, that's been the thrust of the arguments in the matter today.
So ultimately, the big question is former President Jacob Zuma immunized from disqualification in terms of the provision of Section 47.1E?
Well, that will obviously be up for the court to decide. The Electoral Court argued that there are effectively two categories of sentence, aside from the remission argument, but they argued that there are sentences that can be appealed and sentences that can't. And my understanding, the lay understanding of their decision was any sentence that can't be appealed isn't what Section 47 of the Constitution refers to. That is the question that the Constitutional Court must just decide, must decide. And obviously we wait for their ruling and their reasons behind it to know, how this affects Mr. Zuma's ability to be a member of Parliament.
Michael, thank you so much for your time, for weighing in on this issue.